joined by Natalia. Natalia has 15 years of experience in business, in estate planning. She is, of course, a lawyer by trade and focuses on asset protection, real estate litigation, and comprehensive estate planning. So, through the view of this group, through the lens of this group, investors of all different stages, some buying their first home or that have their first few rentals, others have done many homes, many projects, and own many homes or many properties. Natalia can help with anything related to your real estate law needs, but also if you don't own property just yet, estate planning makes sense for everybody. So we encourage you guys post call to reach out to Natalia. She is highly qualified, graduate of Stetson Law, and as she just mentioned, studying for her LLM, which is a master's degree in taxation, a very difficult degree to earn from the University of Florida. Go Gators! So Natalia, if you just want to say a little bit maybe about your business that I didn't touch on, and then we'll jump into estate planning 101 for real estate investors.
Yes, so I've owned LCO Law now for about 13 years. And as you mentioned, that is who we focus on. Our clients are almost all real estate investors, and as it tends to be, entrepreneurs. So sometimes they have non-real estate related businesses, but I absolutely love working with real estate investors. You all are kind of like the root lifeblood of all of these other businesses that we have. And in real estate investing is huge, not only here in the state of Florida, but there's lots of other states where it's an appealing thing. So it's really important for you to know how you hold these assets, the risks involved, the kind of like where you becoming incapacitated or passing away makes an impact. And so that's why I prepared this presentation. But yeah, I think you kind of nailed my background there. So I appreciate that, Mark. Okay, so do you want me to just go right to it? That way we
Let's jump in. Sure, we'll do about maybe
perfect.
30, 40 minutes of presenting, and then we'll
Mhm.
do some Q&A with the group.
Yep, sounds good. Okay, so estate planning, right? Because sometimes people think, oh, will is an estate plan, and I just want to kind of like wash all that out. Estate planning for real estate investors is tax planning. It's keeping you out of court, both probate court and guardianship court. It's preserving those liability limits for all of your investments. It's minimizing your exposure to creditors and minimizing your exposure to the wrong people. This will be, like that distant relative who raises their hand and shouldn't be involved in what you do, or the person who might want to act as the guardian for your children. A lot of you all are kind of like in that growing stage of your life, so you might have kids. And so it's important to consider all of these as really the nature of estate planning. Okay. Real estate investors, right? For you guys, time is money and liability, right? Because as the longer you do a business, more that you increase your risk of liability just because you've had more exposure, more transactions, more communications. And so those things grow. The way that you hold title to your assets will affect liability protection. So I'm going to touch a little bit on that, on trusts and LLCs, on corporations, because if you hold any of your assets in your name directly, that is now open to liability of your personal creditors, right? The injury lawyers we see everywhere on the billboards, the uh, angry consumer who didn't appreciate the way that you did the work on a property, like all of that. So let's keep our name out as a number one kind of a tip. How you hold title also affects tax liability, right? Different entities have different tax rates, so you need to keep that in mind. Have a good tax advisor that helps you play around with the numbers and see, is this going to work better for you this year versus another year? So that's one of the other things about having entities. You can have that tax flexibility. I'll be addressing also carryover versus step-up issues because depending on how you title things to leave them for family members or gift things or pass things around, we'll have different bases to use. If you don't know what a basis is, just think like, right, I bought this for 500 grand. That's my cost basis. I made 50 grand worth of improvement. That's now affected my basis and made it an adjusted basis. Carryover just means if you transferred it in a specific way, that's the basis that carries over versus a step up in basis is something unique to leaving assets at death. It means it gets all revalued at the fair market value of what is now the asset's worth on your date of death, and that can save a ton on capital gains taxes. The other issue that, is important is because if you guys have businesses, and you don't have somebody legally designated to keep operating that business while you are gone, that is now a frozen business. It cannot be, nothing can be done with it unless somebody is appointed by a court at that point to deal with it. And getting to court is a pain in the tuchus. It's expensive. And it's a lot of reasons why assets kind of get lost and then become part of that unclaimed funds, including businesses. The way you hold title also will affect insurability, right? We want to reduce our risk of us being the ones that come out of pocket on all of these potential liability issues. So if it's not properly insured or the wrong parties are insured, that's going to affect our ability to make those claims and pass over the money burden to the insurance companies. And then how you decide to title those assets overall to kind of escape probate will have an impact on whether your family or your business partner is stuck waiting for a court order to be able to do anything with the business versus just being able to administer things behind the scenes privately. Okay, so real quick, probate in court. This is what I want you to learn to avoid. It is a lawsuit for your creditors, okay? In probate proceedings, the parties that get notice for everything that are required to receive notice are your creditors. Known creditors, unknown creditors require publication notices, and it's just designed for them. That's why if you ever look at a will, you're going to see something that says, "and the residue of my estate," which just means the leftovers, will then go to my heirs. So it's leftovers after creditors, after administrative expenses. And I've used a little example here of like a $1.5 million estate. So let's say you own your house and maybe like 3 rentals. Okay, that's about $1.5 million estate. It's going to be about 90 grand in legal and administrative fees in a probate proceeding if nobody fights it. So that is the bottom cost to get that administered in formal administration. I want you all to not have to deal with that. And there are ways to do that. So long as you're competent and you have the ability to make your decisions now, that's the time. If any of you have minors, part of the other problem of probate proceedings is that minor children cannot receive more than 15 grand in assets. It's just not a thing. So then if you have minors, for that end to receive anything at all, you're going to need conservatorship proceedings, which is just another 7 to 10 grand tacked on top of that. So avoid that at all costs. So here's also why you should worry, right? Because remember how I said it's about creditors and being in favor of creditors? These are all the lawsuits that can come up for you and also for your estate, right? Deposit claims, well, there's a drug dealer on the property and now the neighbor's suing, management liabilities, property management. You may have had some injury to workmen that were doing repairs. Maybe there's an insurance dispute, partner disputes. Those are very common, especially if you have poorly drafted joint venture agreements or none at all. So these are things that are common, and you will see this as part of a probate claim issue if you subject yourself to probate. I want to talk about asset protection too, because asset protection is essential to consider as part of your planning, right? How you're titling your things, how you're structuring your things, not only to keep them out of probate, but also to keep them out of creditors' hands. And the big important reason is that once you have a claim, once you got that letter from that attorney, or even that angry letter from like somebody that bought a property from you, maybe they didn't have a lawyer, but they drafted it themselves. That is a notice of claim. At that point, it's too late to move your assets around to try to protect them. Why? Because if you start moving assets after a notice of claim, it's called a fraudulent transfer. And every single state in the country has fraudulent transfers acts. And even the federal government has fraudulent transfers acts too. Florida's is particularly painful. Okay, there are many states where if you've transferred an asset in that state, the look back period, meaning them undoing the transaction, is usually only up to 2 years. In Florida, look back periods can be 4 years to 20 years. That means they'll go really far back in undoing transactions if there's anything suspect showing that you had a notice of claim and you moved assets around. You try to then put it into an LLC, then put it into a corporation, then put it in somebody else's name. So we have to be really mindful that now, before you have any claims, is the time to put those assets into entities that protect them in limited liability. Now is the time to retitle some of those personal things that you have that maybe you don't use for business, but you want to isolate from your businesses. Now's the time to maybe put those also into different types of entities to isolate them from potential creditors' claims. Because,
Natalia, can you
yeah.
can you can you give me a like real life circumstance where you've seen an investor trying to do an asset transfer to protect themselves from a lawsuit? Like what did that circumstance look like, and where did they transfer the money, and just kind of
So
the mechanics of
I'll give you a good example. So there's an investor that did, some upgrades to the property. The upgrades weren't pleasing to the other person. They got a notice regarding like, oh, mold, and we're going to sue for all this other stuff, et cetera. But the person had the property in their name prior to selling it. And they had several other investment properties in their name, right? So they had tried to then convey them. They had them in their name personally. They tried to convey them into their spouse's name, right? Which spouse is a related person. It was a
it?
transfer not for value, right? You are deemed to essentially have control over your spouse with respect to those financial decisions. And so the whole thing was undone. And even the account that they had and shared with a family member was now subject to funds being taken out to satisfy the issue of that claim because it became a judgment. Like they waited too long. They didn't even defend. They didn't fight it. Became a judgment. And now it's like, now this is going to attach to everything, including those transfers that you made to your wife of those other two investment properties. They're getting undone. And now they're going into the hands of that creditor to satisfy their claims. So this
So
is
what
what
you're
I mean by
suggesting is
undoing.
there's a way to take that property that the tenant was in that was suing, and have that property in an asset protection envelope, if you will, that will
Mhm.
protect that investor from their other assets being pursued in the event of a lawsuit,
Yes,
right?
yes.
Yeah.
But you have to have it in that envelope, right? As you called it, Mark,
Yeah.
before you have any claims.
Okay.
Because
Okay.
once there are claims made, it's too late to move any of your other things around to protect them, or even to move that thing around to protect it. Okay. Um, and there's also at the federal level, there are some criminal penalties that can get imposed if you knowingly and with the intent to defraud a creditor transferred assets, which, most of the time when people are trying to hide assets, it's because they're trying to keep them out of creditors' hands and they know there's a creditor. Okay, so I'm going to go over some different entity options for you guys with respect to asset protection because we like those envelopes matter. The kind that you choose matters, right? So I'm going to address LLCs because it's like the darling of the state of Florida and several other states, but it really does depend on what state you choose to open one up in, the kind of protection you have. Florida, for example, doesn't really have much liability protection for single member LLCs. The reason why is because we had a Florida Supreme Court decision called Olmstead back in 2008 that kind of screwed things for single member LLCs. After that decision, the Florida legislature revised the whole Limited Liability Company Act, but failed to cure that predicament for single member LLCs. So multi-member LLCs now have protections, but not single member. Um, so the state really matters. Okay. Taxation with LLCs is super flexible. Why? Because it is a pass-through, purely elective tax thing. It is not deemed to be its own entity under the tax code. So if it's a single member, it's taxed as a pass-through, just like, hey, it's a schedule on your 1040 return. If it's a multi-member, as a default, it's taxed as a partnership, which is probably the best thing you want to choose if it's a holding company for real estate investments. I'll tell you why in a minute. Um, you can choose to be taxed as a C Corp. You can choose to be taxed as an S Corp. So there's lots of flex in there. You do have to maintain company formalities. Okay. If you just have an LLC, if you just like went on Sunbiz and created this thing, but have no operating agreement, no formalities, no annual meetings, no records, no treating it like a real distinct entity, those creditors are going to be able to shred your entity to pieces when it comes to creditor grabbing things. Okay. All right. There's also generally tax advantages to distributions if you have that pass-through default treatment, simply because it's taxed to you. It's not seen as a separate thing, so there's no transfer taxes involved. Corporations are a whole nother beast. They are great for asset protection purposes, right? There's a lot of case law. Corporations are some of our oldest entities, and a lot of that case law is very, very determined to treat a corporation completely separately and distinctly from its owners, right? So that's one of the pluses for liability protection. It depends on the state too, also because some states are expensive to have those annual filings. But a corporation, as a default, is taxed as a C Corp, okay, which is a double taxation structure. So you have to take that into account. Years ago, it used to be not so preferred. That's why LLCs became so popular because the corporate tax was a much higher rate. Now it's at 21%. It might even be lower depending on what this administration does. And so it might not be a bad option nowadays for certain kinds of business things. Like I said, I wouldn't recommend it for holding companies for real estate investments, but maybe if you've got like a management company or something like that, you might want to think about the additional protections under a corporate structure and the fact that it's a lower tax rate than it used to be. You still have to follow those formalities. Okay. Your company should have bylaws. It should have those corporate records. It should have all those separate and distinguishing emails and phone numbers and websites and all that stuff. But distributions are subject to taxes. So I'm going to explain that here. There's a section of the code which says if you distribute to your shareholders, right, the owners of the company, an asset that has appreciated, aka real estate, for example, right? Because we all want our real estate to appreciate. So if you distribute that, the difference between the value of the property when it was first acquired by the company and the value of the property when it's distributed, that difference is counted as capital gains. Is going to be taxed as a capital gain. So trying to move a property from your corporation into your name, which sometimes people try to do for refis, isn't going to be very beneficial economically. Okay, if you have a
So
corporation.
this is really key. This is really key. So I want to put
Yes.
it out there. So
Yeah.
so you're saying that you buy a property for, let's call it 500,000. Some years go by, now it's worth 800,000. You own
Mm-hmm.
that property in ABC corporation,
Or,
and
yep.
now you want to transfer it to a different corporation because you're getting more sophisticated in your investing and you're trying to set up things from an asset protection perspective. So you try to transfer from ABC Corp to XYZ Corp, and that becomes a taxable event, just as if you were selling the home, correct? Is that right?
So that one's a little bit different because you're talking about a reorganization. So transferring
Mhm.
it to a whole another entity that's going to like take, let's say, all the assets would be different. But here's where it's the biggest thing for real estate investors. When you go, oh, I've only had this corporation maybe a few years, right? Maybe the asset appreciated 100 grand, not 300 grand, right?
Yeah.
And I want to refi. I want to take money out on the equity, right? But it's unlikely they're going to give me a loan with the rate that I want. So what I'm going to do is just transfer the asset in my name, take out a refi, and then I'll put it back in. But the problem is you can't without capital gains taxes on that difference. Right. So at that point, you might realize, ooh, the points that I'm going to get on a loan are much lower total as a cost than having to pay capital gains taxes on this accumulated value difference. And here's the other thing. Don't think that this just applies to C corporations. This also applies if you have made an S election for your entity. So it applies to an LLC that is taxed as an S corporation. This is big. Okay.
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 So I have one more question
Mhm.
here because I think it's really important. So most of the folks in the group, as they're doing active projects, we have a lot of rehabbers in the group or flippers, and we also have some spec builders in the group or investors doing spec homes. So we're typically buying these properties I know I'm going to hate to say this, in a single member LLC, right? Where it's just
Mhm.
us and we're the sole owner, agent of the LLC. We own that LLC and we're buying it thinking that there's some asset protection there, or because the hard money lender requires us to purchase
Under an
properties in an
entity.
LLC.
Yep.
But you said just a few minutes ago that there's laws have passed where there's really no true protection for that single member LLC. So I want you to just touch on that and maybe how we can protect ourselves in that situation by maybe opening a different entity or different
Yes.
structure.
So, and this LLC issue is really a Florida issue. It's thanks to our Florida Supreme Court making a giant mistake in the legal determination because it made sense in an equitable point, right? It's just like the way that this guy behaved with this company was egregious. And so it made sense to pierce it to satisfy the judgment creditor in that case. But the problem is that it then affected all single member LLC owners with Florida limited liability companies. So if you're being asked, right, what's the simplest way? If you're being asked to open up an entity, an LLC, do it in a different state. You can do it in an investor friendly state like Wyoming, Nevada, any one of the private ones. Okay. Um, Delaware is really private, but it's also very expensive annually to maintain. So Wyoming, for that reason, is one of the really popular ones right now. Okay. A Wyoming single member LLC will have all the protections of a Florida multi-member LLC. And it's also really private. Nobody can see who the owner is. So that's added bonus. Okay. Um,
Well, and it's probably just as simple to open one in Wyoming as it is to open in
yes.
Florida, right? All everything's done
Yes.
online. It's just a matter of paying them fees as
Yep.
opposed to paying Florida fees.
Yep. And the annual filing fee and the like origination fee to create the entity is actually very cheap as well. And there are plenty of companies that will act as a registered agent that do it very economically. So with respect to that, it's a worthwhile if you're gonna just open up an entity because you've been told to open up an entity. Try to not pick Florida, okay? If you're just the only member. Okay. So now let's talk about some trusts, because I also want you to know that there are entities that exist outside of an LLC and a corporation, right? And Florida has one of these very unique structures that you could also use to hold your real estate. They're called Florida Land Trusts, right? So Florida Land Trust Act is one of six in the country. There's only six states with a specific Land Trust Act. We can thank Illinois for coming up with that idea. Florida land trusts allow you to hold a piece of property or an interest in real property in a way that the trustee doesn't have personal liability. The beneficiaries don't have personal liability so long as their interest is only personal and not real property. It's got to be in writing. So any of you that have thought that you've created a Florida land trust deal by just titling it in the deed in the name of this land trust, blah, 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 but you don't have an actual separate written land trust agreement, you don't have a land trust and you don't have that protection. It is actually legally owned by the individual or entity that you named as trustee and not by a land trust, by the way. The taxation for Florida land trust is passed through. All right, so it is taxed, the income, the expenses, that's all passes through to the beneficiary or beneficiaries designated. Okay. There is something for you to understand if you're using these for sub-twos. I'm actually writing my thesis paper on this. Sub-twos are subject to the at-risk rules. That means that if you are taking over a mortgage, but you didn't actually become it didn't get like novated into your name, or you didn't get an actual assignment from the lender that says that you are now the one taking over these payments and have personal liability, then your basis is going to be a lot different than you think for the depreciation deductions and all of that. Okay. And it holds, again, only real property interest. What's a real property interest? It's fee simple title. It's an easement. It's a mortgage is a real property interest. Okay. So you can hold all those kinds of interests in a Florida land trust, but remember, it must be an actual written trust agreement. That's the biggest mistake I see. Okay. Florida land trust isolate that as a cocoon. They just, whatever you put in it, it's a cocoon from any of the other assets that you might have or business things. So if you have like a ton of investment properties in one LLC, you're putting all of those at risk because that's too many eggs in one basket, right? Somebody slips and falls here, they can satisfy it from property B, C, D, E, etc. Whereas if you isolate all of those in their own individual land trusts, now the beneficiary can still be your company. Okay. All the money can still flow through one. But it isolates each individual one in its own little cocoon so that creditors cannot pursue satisfying their claims against anything else unless they can prove that you like intentionally did something horribly negligently to actually bring you into the lawsuit. Okay. So that's
Natalia, this
interest.
sounds like something really smart to do for your rental properties. So let's say we buy a property, we either build the property from real land or we rehabilitate a property. And we're doing that all through the LLC because that's what was required for us to secure the financing and this is how we run the business. Can we later on, even after we refinance in that same LLC, can we then put this Florida Land Trust envelope around that isolated property to protect it, or do we have to transfer the title to the Florida Land Trust?
So I would say that during the period that you're stuck having to be beholden to whatever the requirements are of your lender, right? If it's like the construction lender with the payout periods, you might not be able to hold it into a Florida land trust at that time, but you can always convey it into after, so long as you retain control. So if it's the same entity that's got the ultimate control behind the scenes, lenders do not generally care. They will not trigger a due on sale clause because you're still in control. Okay. What concerns them is when you're not, and you've actually transferred it to a third party who is not the person or entity that they approved of. Um, Recently, over the past year, I have seen more of our private hard money lenders, right, be willing to lend to Florida land trusts. Okay. So go where groups of real estate investors hang out because they have the more sophisticated lenders that understand how Florida land trusts work. The other asset protection tool that I don't want to have you miss is the use of irrevocable trust. So these are very different. These are delicate puppies to deal with, but they are used for asset protection of not just real estate assets. Because the thing is, you might have other kinds of assets that you want to keep out of creditors' eyeballs. You might have like a huge amount in investment accounts or crypto or brokerage accounts, so just financial holdings, right? That you don't want to be touched. And so you can put those into irrevocable trusts. Just be mindful that irrevocable trust, unlike pass-through trusts, do have different tax rates. And those are higher tax rates for income produced, both ordinary income and capital gains taxes. So there is a have your cake and eat it too issue here. Okay. It is expensive to protect them in irrevocable trust, but if you do a correct irrevocable trust, those assets will be sheltered from creditors' eyeballs. They're just, like I said, more costly with taxes, more costly with administration because you need to have independent trustees at that point. What's an independent trustee? It's not your spouse, it's not your sister, it's not your brother, it's not your children. It is somebody who is truly independent from you. Can they distribute money to you, the income? Yes, they can be structured as intentionally defective, irrevocable trust. This just means that for income tax purposes, it's yours, but for all other purposes, it's not. Which is just a way to like minimize that tax burden. But you will need, again, that independent trustee. They'll charge their trustee fees. So these can be expensive. But once you start getting up there, you might want to consider this as a tool to safeguard those assets. Okay? All
So
right.
just a couple of thoughts there for the group because they might not be familiar with the term
Mhm.
irrevocable or revocable trust. So, and correct me if I'm wrong. So the way I understand it is that a irrevocable trust has its own tax ID,
Mhm.
and you cannot change the beneficiaries of the trust without the beneficiary's consent, right? Whereas a revocable
Yes.
trust is
Yep.
revocable. You can revoke it at any time. You can change the beneficiaries, and therefore the tax ID is your own as the trustee, right? So the
Yes.
irrevocable trust is actually an entity. Beneficiaries can't be changed. It has its own tax ID, and that's what gives us this level of protection. Where a revocable trust, or I think you called it a pass-through trust, doesn't
Mhm.
give that level of protection. Is that right?
Yeah, and the reason is because revocable trusts have more of a purpose other than the Florida Land Trust, because that's our own little statutory baby that is just wonderful for real estate investors. Okay, it's really investor friendly. But regular revocable trusts are usually used for estate planning purposes to protect you from probate, to protect you from guardianship, but not to protect against your own creditors, right? And you want that flexibility sometimes so that like you can put assets in, you can take assets out, you can change your mind about leaving it to Becky or Sam or Julie or whomever, right? And so they're not considered as completed transfers. until you pass away and they become irrevocable. That's why they don't have a tax ID until it becomes irrevocable. Irrevocable trusts, by their nature, mean you cannot change it. It cannot be revoked without having joinder of all the people that you named as beneficiaries, because they're the ones that are impacted as beneficiaries then at that moment, right? Of the assets, of the income of those assets, of being able to borrow from those assets, etc. Okay. Just to give you guys an idea of how expensive tax-wise it is for irrevocable versus revocable, right? So capital gains taxes. Right now, if you're married, to be taxed at 20% on your capital gains earnings, you have to make at least 600 grand, okay? To be taxed at the highest level, 37%, as a married couple, it's $731,000 in ordinary income. Very high levels to get to that high threshold. If you have income producing assets in an irrevocable trust, okay, the assets are going to get taxed like gains on capital sale of a house that's held there are going to be taxed at that highest 20% capital gains tax rate after $15,900. That's it.
Wow. Wow.
And ordinary income, right, like rental income, for example, is going to get taxed at the highest 37% once it gets to what? $15,650. So the thresholds are super low in comparison to humans, which is why these need to be very delicately drafted. They need to have provisions that manage and play around with how that income is distributed so that the income tax liability can be minimized. Never, ever, ever try to do an irrevocable trust without an attorney who knows what they're doing with taxes. Okay. All right.
Real quick,
Estate
David
taxes.
Sousa had raised his hand. I don't know if he still has a question, but if he did, I didn't want to, because I'm sure it was on that topic.
Yes, actually, I was talking on land trust. I think you mentioned something important, and I wanted to highlight it. I was doing research on it last year, and there were so many horror stories about people switching their properties into an LLC and getting the banks actually calling on that switch. And they're trying to, readdress the interest rates again because interest rates were so low on some of those properties. And one of the big benefits was by using a land trust, you were able to do that transfer in a more safe way that you will not call on those, I guess it's not a dual sale clause, but in those, I don't know, capacities of the bank to change your term. So I wanted to highlight a little bit of what you were saying on the land trust benefits versus an LLC in some of these property transfers.
Yeah. Now, of course, in order to keep like super pleasant and happy banks, right? If you're going to transfer into a land trust, they're going to want to see that the trustee is the same, right? So if you transfer it from your LLC into a land trust, it's going to be that LLC as trustee of the blah, 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 which might be the best practice for asset protection purposes. My recommendation is if you keep paying, okay, generally as a practice, banks are not going to want to call it due. Why? Because that costs them money. That costs them legal fees, costs them all these administrative things. And if they're continuing to get paid, they don't care for the most part. Okay.
Wow.
You do have to know how your lender behaves. So maybe as part of like your selection process for the kind of bank that you want to go into the official records of the county, type in the bank's name and see how active they are in foreclosing and calling demands and filing notices and requiring mods. That's because all of that becomes part of the public record, especially if they have to file foreclosure, which is the due on sale thing or due on transfer. Okay. One of the other reasons why land trusts are sometimes helpful tools, especially if you refinance something or had to use it in your own personal name, is because a land trust is technically an estate planning instrument. And so under the Garn-St. Germain Act, which is federal law, the banks can't call it as due on exchange or due on sale because it's an estate planning instrument. Now, they don't know who the owner is behind the scenes of that beneficial interest. But that's one of the reasons why Florida land trusts, in my opinion, are underused and should be used more for these real property holdings. That's a great question. Okay. All right. So estate taxes, right? We have a enormous unified credit. Unified just means that your estate tax liability credit is shared with gift tax, gifts that you've given out during life. Right now it's 13.9 million. That sunsets at the end of this year to 5 million adjusted for inflation. Why? Because when the 2017 tax changes were done, they were set to sunset. Okay, they weren't permanent. The only one that was one of the permanent ones was bringing down the corporate tax rate to 21%. Everything that is under your dominion and control, even if it's not titled to you, is part of your gross estate. You need to know that. Gross estate is what the tax code uses to determine where we start calculating your tax liability for estate tax purposes, okay? This is where people make some mistakes when they think, oh, I've heard about irrevocable trust to pull it out of my estate. But it can be pulled into your estate if you kept control, if you remained the trustee, if you did all these things that to the IRS say you have dominion and control. Therefore, this is an asset of your estate. Okay. Even joint bank accounts, the whole amount of money can be pulled into the gross estate for estate tax purposes. So if you have a joint account with like a sibling or an aunt or a parent, but you're the one that contributed all the money, it's going to be pulled into your gross estate. Okay, for estate tax purposes. So know that those calculations come into play even if you've got joint ownership.
Good question, just that we don't miss it. So the unified credit, this 14, almost 14 million amount, you're saying at that amount as of today, that amount is, but that amount is not taxed in the event of an estate, or that amount is taxed. Explain the unified credit, I guess, is
Yeah.
I'm asking.
So let's say you pass away and you've done very well with your real estate business and you've got 20 million, okay, worth of assets that are the gross estate. You'll take 20 million less, the cost of administering your estate minus that 13.990 million if you die this year. And the rest is what's taxable. Okay, the rest is what's subject to that 40% tax. That's what that credit essentially kind of means, right? It's
So
not
right
like
now,
go ahead.
God, I'm sorry. Go ahead, please.
No, it's because sometimes, right, we think of a credit, we think of like par for par when we think of the actual like tax bill that we have at the end. I don't know why they called it unified credit. It's really more like a unified deduction.
Right. Exactly.
But or you could think of it as a unified exclusion amount is more appropriate, but that's how it works. And they tally together what gifts you gave out during your life that were taxable over the annual exclusion amount and what you have at death. And that number compounded together is what then you can subtract that 13.99 million from, or whatever it is on your date of death. Okay. These numbers vary a lot. Congress likes to use this as a fun political tool. So be mindful that if you're in the millions, you should always be doing tax planning. Okay. Those who plan well always have a lower tax liability. Even just being married is a way to minimize your tax liability because you get to stack spouses at annual amounts, right? So 20 million, if you pass away this year, right? But you were married, well, your spouse, depending on how you left it, your spouse can use some of that to like cram it down. And now you've got a almost $8 million exemption. And all of a sudden you have a non-taxable estate if you do it right. So you have to, again, communicate with somebody that will teach you these little tools. I'm just kind of going over in a broad surface. Okay,
So just to
so that's what I
understand
mentioned.
understand the view of us as investors. So, many of us are accumulating properties because we want to enjoy the appreciation over time.
Yep.
And, many of us want to keep these properties, forever and definitely, and just use, of course, the active income to support our lifestyle. What you're saying, in the event, let's say we accumulate property and we have $20 million in equity. As it stands right now, there's a potential when I pass, if I were to pass, let's say even prematurely, that I can pass it on to an heir and it not be a taxable event. Is that right? Or is there always some level of taxes involved when you have appreciation in the assets?
So there's some levels of there's some activity that you can do, right? There's a smorgasbord depending on whether you're married, whether you're not married, what kind of beneficiaries you have, because people with children can use some tools like family limited partnerships that people without children can't necessarily use. So it depends on where you're at and not just how much you have to be under tax liability. I already kind of covered this, right? The ordinary income, irrevocable versus revocable. Just know that the irrevocable tax rate also applies to estates. Okay. So if you decided to go with a will, your estate is also going to have the same tax issues. It's not going to have any of the fun planning that you can do to minimize tax consequences that you would under good trust-based planning. Okay, so those are those fun little rates, right? There is a give and take. Remember how I talked about carryover basis versus step up in basis? Because step up is how you save a ton of money on capital gains taxes for your family, right? You guys are accruing all these very highly appreciating assets. It's what real estate does. That's why we are willing to take maybe not so great in rental income for all that equity that's building up, right? So the issue becomes, if you've transferred a lot of these like highly appreciating assets into irrevocable trust, or you acquire them through irrevocable trust because you're like, whatever, they're not producing a lot of income, so the income tax consequences aren't going to be big. I want this out of my estate because it's going to appreciate, right? Just remember, it's not going to have a step up in basis when you pass away. They're going to have a carryover basis. So when those assets get sold, it's going to have high capital gains tax consequences. And that high capital gains tax consequence is not easy to pass through to your beneficiaries of the trust. You essentially have to terminate it under the D&I rules. That's not great. Okay, this is another reason why I'm like, be careful about what you put into irrevocable trusts.
So for the group, so the carryover basis is really your cost basis for the property that carries over to the heir, and then they're
wherever
paying
you transfer it when
capital
it's
gains just
irrevocable.
as if it were you, right? Now, a
Mhm.
stepped up basis is my cost basis is the value of the property when I inherit it instead of the value of the property when it was purchased
It's
by the original owner, right?
Yeah, just a little tweak there. It's not the value of the property when you inherit it. It's the value of the property on the date of death of the decedent,
Okay.
or there's a second option where it's like 6 months after. Because if property lowered in value, you want to use that 6 month date to bring down the estate tax liability. Okay. So as a matter of fact, if there's ever an estate tax return owed because your spouse died, right? Your buddy died, you might want to be like, hey, wait until at least 6 months pass before filing that return. Because you can maybe take a lower valuation, right? We do know that sometimes property values do decline. That's what we saw working toward the end of this year, since interest rates kind of finagled things. Okay, so why is it important for your agents, the people you're appointing to all of these roles, the management of your company, your personal representative, if you decide to have a will, a trustee, if you decide to appoint a trustee because you wanted to do some estate planning to actually plan for taxes, why is it important for them to not forget about taxes? These are just some of the forms that will be due. There's a ton. It's a ton of forms, okay? And whoever's in charge has personal liability under the Internal Revenue Code for the taxes that are owed. Okay? So if they get it wrong, that's now a lien on their assets. They need to understand that they cannot do this on their own, especially with you guys who have highly appreciating assets, who will probably be, if you're successful, right, facing an estate tax planning issue. Just know that there's a lot involved. Okay. I wanted to add like some bonus did you know things for you guys, right? So you may know about that 199A deduction. If you don't know about the 199A deduction, oh my God, go whack your CPA with a newspaper. This is available for sole proprietorships or partnerships or S corporations. It is a way to get 20% off your tax bill. So, please talk about it. Accelerated depreciation, right? Remember that you can do cost segregation on certain kinds of non-real property parts of real property to heighten up the depreciation deductions, because you might have a year in which like your income is really nice, but you're like, I don't want to have to pay taxes on all of that income. So you can appreciate that in a way or accelerate it. You can get bonus depreciation on things that are not real property, but hey, again, you all, for that reason, entrepreneurs, mix up your bag with different kinds of businesses. That helps you offset tax liability from all the places where the income comes in. And then, of course, about 1031 exchanges, right? This is the way that you defer that gain as you're switching up assets so that when you pass away, your heirs can get what? The step up in basis, right? Okay, which is how you save up on all that capital equity accumulated over the years. But I want to talk to you about different things. One, if you use depreciation, be aware that the tax man gets it back. Okay, there's a recapture tax. What you've taken out is depreciation. There's also a 1033 way to minimize tax liability. And I wanted to bring this one up because we've had a lot of casualty events in the past year. Just look at what LA is experiencing, right? All the fires, all the property destroyed. We had 2 back-to-back hurricanes here. We might even have some casualty issues as a result of the random snow in North Florida, right? Our structures are not set up for this. So there's probably some burst pipes and things that are going on. If you have a casualty claim, okay, something due to hurricanes, fire, etc., and you get some money from your insurance company and you need to buy a replacement property, you can defer the gains from the prior property into the new property by just buying one that's a little bit more expensive, okay? Under 1033 of the tax code. This one's not often discussed. And it's not like 1031, which is limited to real property, okay? This is also like cars and any other kind of capital asset. So there you go. It's a little tool there. Okay. There's also a safe harbor on those bonus depreciation things. Okay, so you can deduct like in full up to $5,000 worth of like an upgrade that you did. You don't have to necessarily depreciate that, so long as you've got a written capitalization policy in place. You have a good accounting of your expenses, because if you don't keep those financial statements, that deduction amount for improvements is only $2,500. So keep good written records. It's worth it if you want to bring down more of the money tax liability wise, right? Okay. I also want to bring up this one because some of you might decide to be hard money lenders or are hard money lenders, or like lending money out, making some money on that passive income version, right? So this one, okay, what you can deduct if somebody doesn't pay you as a lender varies on whether it's business debt versus non-business debt. How do you make it business debt? You treat it like a business. What's the easiest way to make it business debt? You make a company where that's the company that is your lender company, right? So you create some standards that say like, here's my underwriting requirements for lending out, and here's the kind of like clients, customers that I'm looking for as my borrowers, blah, blah, blah. You create something that says you're treating it like a business, okay? Because if it's a business debt, you can, any loss, right, you can't recover or can't collect the rest of what they defaulted on, is then going to be an ordinary deduction, which is a great way to reduce a lot of your income, right? Versus a capital loss deduction. Does anyone know the difference as to like why you might want to take a bunch of ordinary loss as opposed to capital losses? Capital losses can only be offset against capital gains. So you have to have had like sold a property or sold some stock or something like that, and only up to the amount of capital gains plus $3,000. If it's an ordinary loss, it can be deducted against all your ordinary income and then carried over. So that's why you might want to have it as a business, okay? And if it's business debt, right? Like you are the business and they're your borrowers, you can also deduct partially worthless debt. If you were not treating it like a business, right? If you're just doing it in your name and maybe it was a one-time thing and you didn't do all the other aspects that I recommended, you can only deduct it if it's wholly worthless. So there's a little bit of a difference there for you. And that at-risk rule that I wanted to bring up again is essentially, in a very simplistic way, let's say you decide to buy a house sub 2. You buy it in a land trust, right? You put down 10 grand of your own money. You borrowed maybe 50 grand as a kind of like a second mortgage thing to have enough money for the seller to be happy to go away. And then you took over the mortgage. Okay. Under the at-risk rules, your basis is 60K. It's the 10K plus the 50K you borrowed. Your basis is not the purchase price. That's the assumption amount. You cannot deduct for purposes of, again, depreciation or anything like that, more than 60 grand. Be knowledgeable about these at-risk rules. That is part of the issue with sub 2 transactions. Okay. So, and then I've just listed some of the things. There is an example of personal property that can qualify for bonus depreciation, like some perks. Mark, I'll be emailing you this, that you can hand this out as a tool for all of the people in the group. Okay. All right. Succession planning. You are all business owners. Okay. If you have a rental property, you have a business, even if it's just like a sole proprietorship, which please remove it out of your sole name. You are putting all of your personal assets at risk. But succession planning, right? You need to have written terms that say what happens to your shares, where do they go? You need to say who can step up and be a successor manager if something happens to you. You could become incapacitated because somebody ran into you, right? And all of a sudden you can't make deals anymore, et cetera. Or maybe you have a stroke. All sorts of things happen. It needs to say how the assets within the entity are titled. It needs to say whether what you've conveyed over into your business you gave as a loan or it was a capital contribution, because those have different kinds of qualities if something happens to you. It needs to address what I call the D's of doom, okay? Divorce, disability, death, disagreements with partners, right? Done working, retirement. So all these things need to be addressed in there. It needs to have standards, timelines, like for example, can your partner buy you out if you have a partner? How long can they buy you out? What's the right of first refusal? Do they get dragged along if you get an offer? Can they tag along if you get an offer? All those things. And also it needs to address how things are taxed, especially if it's a partnership. Oh my goodness, do you need to have clear partnership delineation in your succession plan, in your business agreement? When you're appointing people, okay, people need to be financially responsible. They need to account for all of the monetary and property transactions in your business. You need to teach them how to do that. They need to be comfortable dealing with professional advisors. Please do not appoint anyone to be the successor in your business that thinks that they know everything. Okay. Always verify where they're coming from. And this also goes for joint venture agreements. You have no idea how many joint venture agreement disputes I have to deal with because people did not do their research behind the scenes of who they were entering into an agreement with. They're just like, oh, I got introduced from this other person that I know to this person. And they said they had all this background and experience. And I'm like, what do you know about them? You know nothing. And that's why they're fighting afterwards. And then compensation guidelines also for who you're going to be appointing as agent in these things. Okay. You don't want it to be a guessing game. Cheap mistakes that I've seen some people make. Okay. Entities without governance agreements. Investors that decide, I just want a will. I'm like, you business, never just have a will if you have a business. They use those cheap transfer wills where they are like, oh, I'm going to just put somebody entitled with me as a joint tenant with right of survivorship or tenancies in common or ladybird deeds. Those all have tax consequences, as I've mentioned. Or they enter into those joint venture agreements with a handshake or a one-page agreement that makes me want to cry. Or they lend money without getting security. They don't do promissory notes. They don't do mortgages. They don't do anything to protect their interests. And then it becomes very hard to actually enforce and try to get the money back for you. Okay. As a part litigator, because half of my practice is asset protection and planning and all of that. The other half is litigating these things. So I know what happens. trusts, right, that are just not funded. Oh, I got this trust. I made this trust, but I put nothing in it. Great, expensive paperweight. Like I said, sometimes irrevocable trusts where they're still the trustee and manager. I'm like, that does nothing for estate tax planning. They fail to appoint people in case they become incapacitated. Any one of us can. And risky ones too. So some of the estate planning, incapacitation planning documents I've seen powers of attorney, where they say, and my agent has the power to gift. Great, you just gave this person the authority to move all your assets wherever they want. Okay, don't do that. And then not being up to date with income tax returns. If you are late on income tax returns, you are creating all this liability for your loved ones that are going to step up and act if something happens to you, when something happens to you, for all those prior years that you didn't do your tax returns. Okay, don't do that to them. I also put in here that there are states that will tax a trust if there are beneficiaries that are residents in any one of those states. So if you have a Florida trust, but you got beneficiaries that live in California, California is going to tax that trust too. Just know. Maybe encourage your loved ones to start moving away from those states to more tax-friendly states. But even Tennessee, which is a beloved darling of Florida residents, has that issue. Okay? Be mindful of it. Although Tennessee did finally recently get rid of their estate tax. Yay! Okay. All right. So, summary for you all. The right kind of planning, depending on your assets, depending on your business, depending on how you're married, not married, or kids, etc., can save you from liability issues, can save you on taxes, can discourage creditors, because if you don't ever have to open up a probate, well, creditors just don't see that you passed away or anything like that. Income tax planning is a lot more essential to understand than estate tax planning, because income tax affects pretty much everybody that is a current real estate investor. Okay. You might not be at estate tax things, but you will have income tax issues no matter what. Probate and guardianship are too long. They're too long of a process. It's a 2-year period for creditors' claims. And there are probates that I've seen that have gone on for 10 plus years. Don't put yourself in that situation. Okay. The type of entity you pick depends on the type of assets. It depends on the kind of business. It depends on who your creditors are too, right? So you always have to consider, it's not always, I'm always going to use this. I'm always going to use that. No. And the people that you appoint matter so much. Okay. All right. So now, yeah, feeling
That is a very accurate graphic.
This is super helpful. Awesome.
It is. I've learned a lot. Yeah.
Yeah, it's really cool.
So, does anyone have any questions?
I got tons, but I am going to meet you to go over them, by the way. I think a lot of people sometimes get stuck. That's my personal case, is there's so much information, but there's so many scenarios that you have to consider. And I am avid learner, so like last year, I went through so many videos. I started reading books about estate planning, and I put this roadmap, or this map of the different structures, which I'm going to show you, or I can show it to you guys if you want to anyway. But I got the land trust, I got the Wyoming LLC, I got a revocable living trust, I got the Wyoming LLC being the owners. I started creating all this stuff based on what I was learning. And then I start trying to go in depth into this, and you get stuck with, sometimes the cost, sometimes the different opinions. All in all, I think the most important part is that you have to take action, and you have to start at least with basic figures and then get more evolved or more complex as you do it. But it's a lot better than not having anything. We're working so hard as an investors, and sometimes we forget about this protection, not only the planning part, but the protection part. And I am guilty as charged on that aspect. And this is something that, it's been my discussion for last year. And I think sometimes it's finding the right people to work with. I think I am very impressed if I can make a side comment and then let everybody else to ask questions. But I like the aspect of the legal and the accounting part. I think they have to work together. And I appreciate in your presentation that a lot of your comments have that accounting part rather than being two different entities or two different fields, because If you don't have a lawyer that have that accounting smartness, intelligence, then you have to work with a CPA, and then you have to match them both of them together. So this is really helpful, by the way. So thank you very much.
Oh, it's my pleasure. And listen, I still want and recommend strongly that all of my clients that are business owners have a CPA, okay? Even a non-business owner. You should have somebody that knows how to implement the strategies created with a tax professional, okay? Just like I like having the meetings with my client CPAs, because for example, they're the ones that know like how this is filed and how is this taxed and blah, 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 and how to convert it on the form end, right? Because how we assign some things into trust, how we tie those things together really matters for tax purposes. We don't want you to have adverse tax consequences. So those conversations are essential. And there's a type and time and place for different types of advisors. If you're, mom and pop that just have a house and, you have W-2 wages and that's all you've ever had, etc., then a more, still comprehensive, but a more traditional estate plan and advice might be better. Although if you're older, I'd say elder law counselor, right? But if you're a business owner, if you're a real estate investor, you need to have somebody with proper tax training. Because if you don't, there's going to be a lot of mistakes made. There's going to be a lot of missed opportunities to save millions in taxes. And ultimately, like you end up being the loser of that. So we have to think of it this way, right? This is an investment in our business. This is an investment in our family to get it done right.
I think the thought that comes to mind too is, there's that kind of saying that says everybody's only kind of one catastrophe away from, really a really financial dire situation, right? And so you work hard and you own assets, whether that's through, just your primary residence or, rental properties or Airbnbs or whatever it is. And if you're not kind of properly structured, and properly protected, that can all very easily go away with, a car accident or some big lawsuit that comes about, right? And so, I think that this is an area where, lots of investors, probably more, who we would perceive as really kind of big time investors, are also probably not really set up properly. Because I think there's a misconception that if you buy a property in an LLC, you're very much protected. And if you put everything in a will, it's all going to work out very easily, right? And really what you're doing is setting yourself up for huge liability when you're alive, but also for a lot of your wealth that you've worked really hard for to leave to your family to just be eaten up and taken away. So I do think this is a great investment in everybody's business. And I would imagine that it's probably better to start this process and learning about this process and getting into this process for those of you who haven't done a property yet or who are just getting started out. Maybe you only own a couple of properties. Like the earlier the better, so that your CPA and your attorney and everybody that's helping you kind of plan out everything for taxes as well as estate planning, they're growing with you and they're advising you. And to David's point, I think that it's imperative, like Natalia, having a holistic look, because a lot of times when we talk to a CPA or we talk to an attorney, they're only focused on their one thing. And I think that's what feels very overwhelming, is there are multiple players that have to kind of work together to be able to adequately protect us, right? And so having an attorney that understands, on a high level, how this plays into the taxes, and then who can work closely with a good CPA, like that's the strategy. That's the sauce to really kind of protecting everything that you're working hard for. So this was a great presentation. I learned a lot. I do have one question. Obviously a lot of people buy their first home. Mark and I did that. We bought our first property when early on in our marriage. We ended up selling that property and making it was like $120,000 or something, right? Obviously that was just in our name. Is it smart for people who have primary residences? Because a lot of people in Tampa purchased their homes 3, 5, 7 years ago. we have equity, right? Like really good equity. Is it smart to go ahead and put your primary residence in a land trust to protect that? Or do you leave that? Is that kind of a separate thing?
So here's my feedback on you in having it in a land trust, or sometimes the big mistake people make, which is putting it into an LLC. Okay. There are benefits. There are specific tax benefits designated for your homestead residence, for your primary residence. Okay, that's section 121 of the tax code. That's the one that says if you're single and you own your house and you've owned it at least 2 years, right, of the past 5 years, and you've lived of it those 2 years of the past 5 years, you can keep out 250 grand of capital gains. If you're married, it's 500 grand. It's a ton of money that's saved and just excluded, right? But the key is in the statute, titled in your name, right? So titled in your name for purposes of the Internal Revenue means like it's in your name or it's in your revocable trust because it's revocable, right? So it's passed through in the eyes of the IRS in a very unique way. However, it does not work if it's titled in an entity, because an entity is going to be treated as separate and distinct, period. So if you make that mistake of transferring it into an LLC and it's your primary residence, you've now lost out on that section 121.
But if you put it
Exactly.
in a revocable pass-through land trust, then
Right.
you getting the benefit of the homestead exemption or like the capital gains exemption, right? As well
That's the
as
key,
kind of the
right?
asset protection.
So you can put it into a land trust, okay? You can. The land trust has to contain specific language regarding possession and use as a residence. And I also recommend strongly putting in language with references to the Florida Supreme Court, if it's a Florida residence, because not Florida Supreme Court, the Florida Constitution, because we don't want to lose homestead rights for purposes of local taxation,
Right.
taxes. Okay. So if you're going to use a Florida land trust, very delicate, very specific things, but you can. There's also already creditor protection for your homestead. Okay. If it's in Florida. If your homestead is in Florida, there's creditor protection. It cannot be forced, to be sold by any old regular creditor. It has to be like an HOA or your lender that actually has like security based on that house. Otherwise, they're stuck. They can't force a sale. That credit card company, et cetera, they can't force a sale, or that car injury person cannot force a sale already because it's your residence, right? You lose that if you put it in an LLC. So it's all about, if you're going to use trusts, they got to be revocable or have very, very specific residential type qualities. There's this specific kind of a trust for holding a house that can maintain some of that. You just need to be careful with transferring it into trust so that all the very requisite language is there, not only for income tax purposes for capital gains taxes, but also for property tax purposes in Florida. Okay.
Perfect. Thank you.
Mm-hmm.
If the group doesn't have any more questions, I have some. Jillian actually just jumped on if you have a question. I have a few also that I want to get in the lightning round format. I know it's on all of our minds, but Jillian, I'll let you go first.
Mine will be really quick. So I think to Keely and David's point, like what does because one thing that I've run into over time is finding a team that can work well together. So like the CPA that works well with the attorney, right? Because I've had my attorney say, oh, well, you need to ask your CPA this. And then my CPA go, well, you need to ask your attorney. And then neither one of them answer the question. And I'm like, okay, well, I don't know what I'm doing. So, and I'm like kind of at the infancy, like I'm more of a lender right now than I am in real estate. So I don't own any properties. But I have a lot of I have money that's sitting and it's like I need to protect that somehow. So what in your opinion is what is the A team, right? So I need like a CPA, I need an attorney, I need does estate planning kind of go hand in hand with my attorney, or what is the structure?
Okay. So you need an estate planning attorney. I just happen to have like the special sauce of being the estate planning attorney and asset protection attorney for real estate investors. That's my niche. That's what I've been doing for 15 years, right? But you will need an estate planning attorney that understands taxes, okay, because of what you're doing with your money and you're actually getting it to work for you. There's a lot of income issues just there alone. Your CPA needs to be a business-friendly CPA. So not just a CPA that like files all the individual income tax returns, one that deals with businesses day in and day out. Okay. And if you're working your way to doing the more real estate investments, you need a CPA that knows all about those special deductions for real estate investments. So it's an interview process, right? You need a financial advisor as well. Okay. I recommend that you have somebody who is not so much like asset management. You might want to think about somebody that's like hourly kind of an advisor too. It's worthwhile. You should, if you have children, if you don't have any children yet, but if you have children, right, always consider some life insurance somewhere in the mix, and you can use irrevocable life insurance trust as a way to actually pass on a lot more money to your family at your death without it being part of your estate. So that's a tool there. And if your attorney that does the estate planning doesn't have any business training, then you need a business attorney too. So that's the other part. I have an MBA as well. And like I said, I just happen to have the right mix of real estate investors because I have that business planning training, the tax training, the estate planning training, and all the litigation that deals with title issues because I ran a title company for 10 years. So there's unique mixes out there that you can find where they're niched like I am. Okay.
Okay. Perfect.
To point out, so she mentioned financial advisor, and I think what she's very politely saying is some financial advisors will just try to sell you securities. And what you really want is a financial advisor who is a fiduciary, meaning acting in your best interest, and not necessarily a security salesman, which I promise you is the vast majority of financial advisors, even the good ones, right? They only get paid if they're managing your assets or making a trade for you. So be, of course, do your due diligence, but just be mindful of that, right? What she's meaning is somebody who can advise you on your overall financial picture and not somebody who is a quote titled financial advisor. So let's keep
Like
that in mind.
That's advice coming from a multi-year, really successful financial advisor who was in that space for a long time. So,
So okay, I got some. Anybody else? Actually, let me go to the group first, then I got some really quick lightning round questions, and then we'll wrap up because we were taking a lot of Natalia's time. We're so grateful for. Anybody else? And that was a great question, Jillian and David. Great comments. Awesome. Okay.
Just an easy one there.
So I have a couple questions I know are kind of burning on the minds of all of us. So this group that we have investors that are just starting out, some that are scaling their business, let's say 5 projects at a time, and then others that own many rental properties. So we run the full gamut. So I want to ask you a few questions that really touch, and some lenders too, as Jillian mentioned, that kind of touch on what we should be thinking about in these various circumstances. And I know I'm just going to have you answer briefly, and I would recommend everybody go deeper, set up time with Natalia if one of these circumstances fit, and you need broader advice. But a couple quick lightning round questions, and then we will wrap up. So LLCs, many of us are using LLCs to buy properties. We'll own all of our properties in LLCs. Is there a certain amount of LLCs that we should have? I'm sorry, a certain amount of properties that we should have in each LLC. When do we cap out? Is it 3 properties? Is it 5? Should I have one for every property? What are your thoughts there?
I don't recommend having one LLC for each property. That is so onerous. I recommend that you have a different tool that maybe there's one LLC behind the scenes that does the money. So like I said, land trusts to me are a better tool to like individually have assets. Land trust, you don't need to have an annual filing or anything like that. They're private. Okay. They're private. Nobody sees the content of it. So it's great. And that is a better way to isolate assets held in a limited liability company, I believe. There's also different types of businesses. Okay. So if you have a business that is a management company, do not buy your investment properties in that same management company because you're opening up those to the risk and liabilities of your management company issues. So always have, for a different kind of business, a different entity for that business. Okay.
So actually, perfect. Thank you. Perfect. My next question was, if we own rentals, what are the best entities for those rentals? And I know this is case by case, so please answer broadly. But if we're thinking about rentals, what kind of entity should we be thinking about if we own, let's say, 3, 5, 10 rentals? what entity should we be holding those in, or should we explore?
Okay, so like long-term rentals, right? Big concerns are income, for example. Then obviously you got the long-term liability issues of having a tenant there and repairs and needing to do upgrades and all that other jazz that comes in. I love land trusts for that reason, to hold long-term things. If you've got something where you're doing flips and you're not really holding something for too long, there's not a lot of liability risk long term for that piece of property. You buy it, you get rid of it. You buy it, you get rid of it. You buy it, you get rid of it. So if you've got like a flip company business, that's okay to have maybe more than one flip thing at a time because they're just rolling over and rolling over, right? Whereas long-term rentals, you really do want to start isolating those different ones into, like I said, maybe some sort of a land trust entity. Those are very useful tools. They're not the be all end all for every state. Some states will require you, if you own it in a trust, I think like Georgia's one of them, Arizona's another one of them, they will make you record an affidavit of trust to say who the beneficiaries are of the trust as part of the transfer of title. That defeats the purpose, protection and secrecy that is brought by land trusts. So, it's not for every place. If you have investment properties in other states, you will want to consult with somebody in that other state regarding what are some of the better tools. But in Florida land trusts are amazing for long-term investments.
Okay. Two more questions, and then we'll wrap up. So if we're doing if we're doing JV arrangements on property, so we're joint venturing on a property, maybe we are bringing the cash, or maybe we are bringing the sweat equity. What are the type of agreements, or what are the legal considerations, whether that's recording a deed? What should we be thinking about if we're doing joint ventures actively?
So with joint ventures, you want a written partnership agreement. As a default, by law, for tax purposes, it's going to be seen as a partnership. Okay. Partnerships are the most complex section of the tax code, subchapter K. Ask anyone. They're not big fans. So you need a really good written partnership agreement that says how you end it. It's a big one. Okay. What happens if there's disputes? Not just what you're contributing and what percentage of money is being given out, because that's usually the only thing I see in those agreements is how we're splitting it. That's not the end all be all, right? It's also like who is signing off on the loans taken out on behalf of the joint venture? What are the cure periods if somebody breaches? How long do they have as a time period to fix what they boo-booed on? If there's a third party that's a tiebreaker, if it's a joint venture between two people, or what kind of things there's tiebreaker decisions on, right? Because if somebody's like the money person, maybe they want to be the tiebreaker on ultimate decisions involving refis and all those other stuff. So you want to be clear on that. Joint venture agreements, you might want to say that the property is held in a land trust, right? And then the beneficial interest is owned by the partners. You might want to add some information that like maybe the trustee of the land trust is, I like to say, the money partner. Because you want to keep control of your money guy, okay? That's how you hold them accountable. You got the power, right? To sign, you're the title holder. You appear that way. When you have a joint venture, before you enter into a joint venture agreement, okay, you are entering into not necessarily like a long-term marriage, but you're entering into a marriage with this other person. Look them up. Look up their judgments, pull their credit, especially if you're the money person. Oh my God, find out as much as you can about them, because in every single case in which I have a dispute regarding a joint venture, if they didn't have a joint venture agreement with me beforehand, they just came with their mess.
Oh,
They
yeah.
didn't realize that these people had a whole bunch of different foreclosure proceedings in different counties against them, and they had other judgments, and they, all of a sudden just had a federal tax lien. All these things will pop up as really big red flags if you just do some research on the person before entering into that. Bless you, if that was a sneeze.
The last question is similar, and I think you touched on it. So if in a joint venture, there's typically an equity scenario, right? Each partner gets equity. But in some cases, we're lending, right? So we're acting as a lender. what kind of agreement should I be thinking of if I'm just a pure play lender on a transaction? Should I be recording a second mortgage, or is there certain documentation that I should be considering as a lender?
So as a lender, I would say, first of all, like if your partner is an LLC, right? You should have them sign personal guarantees. You should have a promissory note by the entity as well. If you can get a mortgage so that now you have a security interest over their property. You might also want to secure it with other assets. You are not limited to just having a mortgage over that. You can say, hey, I'm also going to take out a mortgage that includes your home to make you act, right? You can have UCC filings and agreements where you're getting security in their shares in their entity. You can get security in their car or their truck that they use for their business, right? If your partner is like a GC, there's so many things that you can use as tools to safeguard your investment.
Awesome.
Now, does your law firm, do you set up joint venture agreements? Do you open land trusts? Can you give us a quick little recap of what services? Because we don't want obviously people reaching out to you for tax advice and things that you don't do, right? What are your services for investors? What should people be calling you for help with and scheduling consultations and getting on your calendar for?
All right, so certainly all of those
Too,
asset
right? So
protection. Yeah. Mark, go ahead and finish your thought so I can
yeah, I was
give you
thinking
the.
a range of costs as well as you're thinking about those things. Just that way we get inquiries that for folks that are ready to take the next step. And just have an idea, and we might be surprised. Hey, I didn't realize it was that inexpensive to do something so important. A
Yeah,
range of
so
costs can
like a land trust, will range somewhere around $1,000 with like the deed drafting, all the way to like complex estate planning can be sometimes tens of thousands of dollars because hey, if you've got irrevocable trusts and revocable trusts and all these other things, it can get pricey, but as a comparison to what you're saving in taxes, it's nothing, right? Um, we do entity agreements. I don't do the formation anymore thanks to the beneficial owners, the requirements under the Corporate Transparency Act. So I have my clients file their own things and then we actually create the governing instruments for their entities. But we do all the land trusts, we do all of the corporate governance agreements, we do the joint venture agreements, we do the notes and the mortgages, we can do the UCC filings. So all that aspect of the tools used, we do. And of course, like I said, I handle estate planning. I most of my clients are somewhere between the $2 million to $50 million range. So just know, right? That's about like the assets that I handle. I do some tax planning for my business owner clients. It is a year-long process that's like quarterly meetings to make sure they're on the right track and we've implemented some things. Once you get to a certain level, okay, you have to have a certain income level where tax planning pain, if you don't land, makes sense. But it is not the end all be all of my business. I prefer asset protection, estate planning, and of course we handled the litigation side of you've got a tenant there and you need to clear up a title issue because like I said, being in the title industry for so long, I know how to correct all those title issues. I know what underwriters like and what they don't like. And as you saw, I've written 4 books. They're all targeted for helping real estate investors. You just put my name on Amazon, you'll find them. And I'm working on the 5th one right now, which is going to expand on that sub 2 issue that I was discussing.
This has been amazing. Lots of great information. Thank you so much for taking the time with the group. I'm sure you'll get several inquiries. It sounds like David is ready to speak to you right away, so that's good. But we really appreciate you taking some time with us and your expertise. And thank you, everybody, for coming. It's been a great
Yes,
call.
thank you so much, Natalia. That was awesome. Thank you.
Thank you. And again, apologies for the calendaring issue,
No
but
worries.
I hope you got a good amount of information. All right. Bye,
Yes.
everyone.
Thank you so much.
Thank you so much.
Bye, everybody.
You're welcome. My pleasure.
Bye.